Inexperience on the part of Master
Yeah.
Control.
Boy, he's definitely not in the groove yet, is he? Oh my
No,
goodness.
he's not.
He's been away too long.
I know.
Good morning and welcome to AM News Network presents the Morning Report with Rachel Baird and Ed Peruta. I'm Rachel Baird and Ed Peruta is seated next to me. Welcome back, Master Control. Getting back into the groove of things, obviously, but we'll give it some time. It's tough being
Well,
away.
your name's getting a lot of play this morning.
It is. Let's just keep that up the whole time.
I know. Why do we have to be on TV? We could have a half an hour. This program is made possible by Attorney Rachel Baird,
So
15 Burlington Road, Harwinton, Connecticut.
So Ed and I are here every Monday through Thursday from 7 to 7:30 a.m. Please join us on Saturdays where we are joined by Matt Tyszkka, retired lieutenant colonel and attorney. Good morning, Ed. Yesterday we left off with me reading the last passage of the dissent by Justice Thomas, which Justice Gorsuch joined in, from the denial of cert in your case, Peruta v. California. And I would like to begin today with that passage as well.
And I would like to say that I was interviewed by Mike Slater on 760 AM radio in San Diego yesterday afternoon. And Mike gave me a lot of time to talk, and I did read in my voice Thomas's words.
That passage at the end?
That passage. And Mike Slater suggested that I have that printed up nicely and framed.
Mike Slater, I am there. I have been there since I read this, and I'm
And
going
I told
over
him
my mind.
it was very emotional and very humbling to think that Justice Thomas at least knows my name and sided with my belief that it was ripe for the Supreme Court.
And that Justice Gorsuch, who has a hopefully long and illustrious period ahead of him in the Supreme Court, joined with Justice Thomas in that dissent.
Right.
So here are those words. For those of us who work in marbled halls, guarded constantly by a vigilant and dedicated police force, the guarantees of the Second Amendment might seem antiquated and superfluous. But the framers made a clear choice. They reserved to all Americans the right to bear arms for self-defense. I do not think we should stand by idly while a state denies its citizens that right, particularly when their very lives may depend on it. I respectfully dissent. He's got a lot of other good stuff in here too. I like his comment in the second paragraph of the dissent where he says, California generally prohibits the average citizen from carrying a firearm in public spaces, either openly or concealed. And that is a lot of what this is about. The average citizen is denied the right to carry, while the elites either don't have to worry about it because they're protected by others, or because of who they know and how much money they have or how much influence they have, they're able to get permits from sheriffs like Sheriff Gore in San Diego County.
And you do know
that's the problem.
And you do know that the California legislature exempted themselves from the law.
And that's what Justice Thomas is referring to. The average
Exactly.
citizen.
Exactly.
And you know what? In 2016, on November 8th, the average citizen spoke up. Thank God.
And the average citizen is going to be part of changing the makeup of our federal courts.
You know, on the other side of things, from the United States Supreme Court down to a district court, state district court in Massachusetts, that also examined a firearms issue last week. I've been talking about this case since I went up there. I think it was on June 13th to have a hearing on the denial of an application for a gentleman to have an out-of-state resident permit, a non-resident permit, right? And the commissioner up there, the firearms board, denied him that permit, and its reasons were rather suspect. Basically, that they didn't like his attitude. They didn't like how aggressively he spoke up for the Second Amendment, how he said that this process violated the Second Amendment. They just generally didn't like his attitude and the questions he asked about the application. And the judge made a decision in that case.
Let me set this up because I think I know where you're going.
Go ahead.
In the state of Connecticut, one of the factors in obtaining or retaining a permit to carry a pistol or revolver is suitability.
What is suitability?
And we have had as a battle cry from this office continually, what is suitability? Why is it that one chief can find you suitable, but with the exact same set of facts, another chief can find you unsuitable? And to me, suitability, unless it is clearly defined by a numbered checkoff list, you know, like 10 points for this, 10 points for this, or take away 5 points for this, or do whatever and come up with a score and say you're suitable. You passed the test. You cannot leave the right to carry firearms up to the personal support or animus on the part of a sheriff.
Because you know what happens.
Issuing authority.
In Connecticut, the local issuing authority issues temporary permits, but the state police can revoke permits based on suitability.
Right.
Not obviously a disqualifying factor means your permit's revoked, but the permit can also be revoked based on suitability.
Well, let me rephrase that for the people on the other side of the camera.
Yeah.
If you do something that makes you a prohibited person,
Become a felon.
the law revokes your permit.
Yes.
If you do something the chief doesn't like, he can revoke it just because he doesn't like it, because he thinks it was unsuitable what happened.
So listen what happens when you have a concept like suitability that's undefined, and the state police have the power to revoke that permit based on the undefined concept of suitability. If you rub a certain member of the state police in the firearms unit the wrong way,
They can revoke.
They can revoke. And if you're revoked and you're looking to be reinstated and you're trying to, convince the firearms unit to reinstate you, because you have to wait 2 years for a hearing before the Board of Firearms Permit Examiners, so you're looking to be reinstated before that 2 years. When we first got involved in firearms issues in Connecticut, there was a detective in the firearms unit named Barbara Matson, and she's retired now, and I can't tell you how many times people would come to me and say, wow, I called up the firearms unit, and that woman, Barbara Matson, was so rude to me and so aggressive and had such an attitude. She said I was never getting my permit back or this or that. And when remember all those notes we got from the database?
She actually put in the notes.
Yeah.
Person has a bad attitude.
Yeah. Suitability for Detective Barbara Matson was based on how much you sucked up to her, right? How much you fed her ego, how much you groveled before her to get your permit back. And if you didn't do all of those things, well, you can just wait the 2 years to go before the board. That's what suitability gets you, and that's what we.
And the attitude was, if you don't do what I want you to do, I'll just revoke, and you'll wait 2 years to get a hearing.
And so what? You'll get it back at the hearing, maybe. But you know what? You've already gone without it 2 years.
I have always maintained that in the state of Connecticut, if you're denied or you're revoked, you make an application to appeal to the Board of Firearms Permit Examiners. The Board of Firearms Permit Examiners has one mission and one mission only, and that is to determine suitability. Because if you appeal to the board, and have a conviction for a felony, they can't even hear your case. You're a disqualified person. You have a disqualifying factor. You're prohibited. They don't even hear the case. So the only thing the board does is review and assess your suitability. And even members of the board have certain animus towards certain activity where they won't give it back.
And they differ because one of them may have an animus towards this activity and the other may not. So it's all over the board. They don't even agree on suitability.
Right.
Because it is an undefined, ambiguous concept. And so in the case in Massachusetts that was heard on June 13th, there was a personality conflict, an obvious one.
Oh, you read it to me.
Between the individual attempting to get the non-resident permit and the individual in charge of whether that permit would be issued.
Let's get into this because I deal with it all the time. I have applied for a permit in Connecticut. I got it. I applied for a permit in Florida. I got it. I applied for a permit in Utah. I got it. I no longer carry a Utah permit, but I applied and was given a permit. I applied for a permit in San Diego. I did not get it. Now, there was a common factor in some of those applications, especially between Connecticut and California, and I guess Massachusetts. Have you ever been arrested? And I can't remember exactly what number it was on the front page of the application, but they give you this little tiny half-inch block, number 19, with the question, and you're supposed to fill it in. Well, on my application in Connecticut and on my application to California, this is what I had to write. Not enough room. See Exhibit A. Now, that's a smart-ass answer to a bullshit question on an application. I don't care how many times Ed Peruta has been arrested. How many times have you been convicted? That is the litmus test in this country. Jesus Christ was arrested by Pontius Pilate and the Romans.
He was convicted, though.
And he was convicted.
Yeah, look at that.
Nelson Mandela was arrested and convicted.
But that's a different
Walesa.
issue. You're trying to make the issue of people that are just arrested.
Okay, so
Not wrongful convictions, but just
let me say this. I learned a word that was used by a person that was referred to as King Richard. Richard Tulisano was the constitutional stalwart or the anchor in the Connecticut legislature before he passed. And he said, if you get arrested and your charge is dismissed, the charge or whatever was ab initio. Now, you know, for a guy with a GED diploma, somebody says ab initio to me,
void ab
I go,
initio.
what the fuck does that? Who's he talking about? I got to go to a dictionary. And you've explained to me what it is, ab initio. Never happened. Never happened. So when you go in to apply for a pistol permit and they want to know how many times you've been arrested, if you're knowledgeable and you go like this, well, I was shooting television news and the police officer ordered me to move and I knew that I was outside the yellow tape and had a right to be there and I refused. He took me into custody. He handcuffed me. He took my camera, put it on the front seat of the car, threw me in the back seat of the car, and I stayed there for 45 minutes waiting for them to move the cars and move the victims. Then he let me out of the car, uncuffed me, and gave me back my camera. I was arrested. I was detained. I was taken into custody for an extended period. To me, that's an arrest. Well, that has happened 5, 6, 10 times in my life, where an officer at the scene has taken me into custody and then let me go half an hour, 45 minutes later. Well, geez, they've just asked me, how many, have you ever been arrested? Please state when and where. And then you got to put on the Exhibit A, you list all of these times that you remember, and then at the bottom you put, there are so many times, I may have forgotten to include some. If you find something that I don't know about, call me and I'll say yes or no.
Yeah, but let's talk about the example of most people who may have been arrested for something once and it didn't result in conviction, or it was dismissed, not, dropped and then ultimately dismissed. Those kind of situations. In Connecticut, there's a particular erasure statute that applies to that. Okay, so in Connecticut, they tell you if your case is dismissed, you can answer under oath that you've never been arrested. We actually have a state statute that says that. So the question is, when you're applying in Massachusetts or California and they ask if you've ever been arrested, does Connecticut law apply that says you can answer under oath that you've never been arrested, or does California law apply? Or Massachusetts, whatever. That's one of the issues.
That is the issue. That is the issue. Because technically, if you say no, they're not supposed to be able to look into your past and even see it because of the erasure statute.
But they do.
But they do.
Because nothing ever disappears from computers.
Well, if you run a criminal history background check from the FBI on Edward A. Peruta, you will see 3 felony arrests from 1983, and it's in the column arrest, and then the column of conviction is empty. What happens is, when you get arrested by a local agency, they tell the state. And then the state tells the federal government. And then you go to court. And the judge dismisses it flat out and says, no, go.
But with arrest, the viewpoint, not only of government, but from people, the vast majority of whom have never been involved in the justice system, and they tend to look at arrest, even when there's a dismissal, as where there's smoke, there's fire. And if you have a lot of arrests, then there's even more smoke to indicate there's probably a fire.
And more fire.
Yeah, so it's hard to get beyond that. That's why when you're sitting next to a criminal client in the courtroom and you're looking at a jury and you say, are you able to presume this person innocent? And they say yes. In your mind, you're thinking, no, you're not. I know you're not. I know when you read the newspaper and you hear that somebody's arrested, you immediately jump to the conclusion they're guilty. I know you do, because you've never been arrested or involved in the justice system, because if you had, the prosecutor is challenging you to sit on the jury and doesn't want you on the jury. So by default, nobody ever freaking sits on a jury who's been through the meat grinder of the criminal justice system. So when I ask you, can you presume this person innocent, and you say yes because you know you're supposed to, I know that you actually don't, because the very people who could see beyond that are excluded from juries.
Yeah. If you've ever, they ask in the voir dire, have you ever been arrested? They don't want you on the jury if you have, because you know what the system's like.
Even if somebody in your family's been arrested.
Has anyone in your family been arrested? If you say yes, I don't want him on the jury.
And by the way, the state doesn't really need to ask that, because all they have to do is click a name into a computer and they know ahead of time who's been arrested and who hasn't.
Well, I've always wondered.
Which defense attorneys don't have that option.
I have always wondered whether the state looks at the jury pool and has a computer that goes through and say, the majority of these people are white, the majority of these people are live in the suburbs, the majority of these people have never been arrested. This is a good jury pool. Let's schedule trials.
Well, I had a case, and in Connecticut, it is not unheard of to have a black client as a defendant and to have a jury pool of 50 people brought in, and every single one of them is white. Every single one of them. Not unusual at all. And one of these white people on a recent jury panel actually said, I am not comfortable, I would not be comfortable sitting on a jury because I'm looking at that black defendant over there, and I'm looking at all these white faces in the jury pool, and I'm thinking she don't have a chance, and I'm not comfortable being part of that. Well, he was out of there. I'm like, yeah, okay. He was out of there because he can't be impartial.
Well,
yes.
If you have a jury pool made up of residents of the city of Hartford who deal with law enforcement in the city, it doesn't have to be Hartford. It could be Hartford, New Haven, Bridgeport, New York City, Chicago, wherever. If your jury pool is predominantly pulled from the city, you're going to get a totally different
But it's
outlook
not. It's
on
pulled
law
from
enforcement.
Hartford County.
But what I'm saying is that's correct, and we don't know exactly the formula for arriving.
We did. We found out that one time, but I can't remember. DMV.
Voter registration,
unemployment?
DMV.
Was it
I think they use unemployment.
Yeah. Well, you know, I want to make sure I get to this decision that the judge wrote. It's dated June 21st.
But read what he said about suitability.
I'm going to read that last. First, I'm going to read how the judge viewed the issue between the issuing authority and the applicant. And the judge said, I'm not going to say any names here, the communications between the applicant,
Your client.
yeah, wait, during the extended application process, the applicant strongly disputed that his answer to question number 5 was false and that the firearms training course he completed was insufficient. In these communications, the defendant's tone was adamant, insistent, and argumentative. Sound familiar?
Whoa.
To a significant degree during these communications, the defendant was unwavering in his position. And he's calling him a defendant, but he's really, the defendant's the issuing authority. The defendant's tone was partially based. Why is he calling him a defendant? It's a little. It's the petitioner. The petitioner's tone was partially based, as he stated, on his claim of a constitutional right to bear arms. In other words, he was challenging the system. He said, why am I even going through this suitability process? I don't get it. This violates the Constitution. In sum, it may be said that the petitioner was aggressively debating his position with respect to these matters. And when you're an applicant for a pistol permit where suitability is an issue, not many people aggressively pursue their position. And this is why, because if you do, you're going to be denied and you're going to have to hire an attorney probably to represent you in your appeal.
So cut that in half. The issuing authority complained about his aggressive defense of the Second Amendment, and the judge said, well, he's just aggressively arguing the defense of the Second Amendment.
Well, the issuing authority didn't complain about his aggressive defense of the Second Amendment. They didn't say that. They said he was belligerent, he was volatile, and because of those characteristics, if they give him a permit, then if some road rage incident happened, then he might become belligerent and volatile and use his gun. That was their thinking, because he's being argumentative with us and not respecting authority. That's actually what they said. We think he's going to go out and shoot somebody. It's exactly what they said at the hearing. Now, there's a prior case in Massachusetts, so I didn't think this up, that said, you know, there's no standards of suitability here. So the issuing authority, when they rely on suitability, we're going to kind of hold them to a higher standard, because until they make regulations or have some sort of standard to give the court parameters, we're going to give the benefit of the doubt to the petitioner. And I argued that to the court. So if an applicant is denied a license, he may petition the district court for judicial review. A justice of the court, after a hearing, may direct that a license be issued if such justice finds that there was no reasonable grounds for denying such license and that the petitioner is not prohibited by law from possessing the same. So in Mass, they don't have a board of firearms permit examiners. You go right to the district court. In considering whether an applicant should be granted a license or a renewal, the licensing authority has been given considerable latitude. An applicant may be denied a license if he is determined to not be suitable. The Executive Office of Public Safety and Security, or its designee, has not promulgated any regulations governing suitability and therefore has provided applicants and license holders with little guidance on what it means to be a suitable person. In the absence of any such regulations, individual suitability determinations become more susceptible to attack on the grounds that they are arbitrary and capricious. The petitioner's request to issue a license to carry a firearm is allowed. Thank you, Judge. That gives me chills that a judge understood that.
This is a major problem in this country. Now, using somewhat of that theory, I was talking on Mike Slater yesterday, and I said, your issue in San Diego is the sheriff, Bill Gore. Bill Gore has the authority, has the right to assess people more liberally and not as narrow as he does. He has the ability, like other counties in California, to say, you don't have a criminal record, you're employed, you're married, you have children, you own a house, you own property, you're a responsible citizen, here's your permit.
And he has the ability to say, I don't like your face, so you're not getting a permit.
Right. He has the ability to say, this guy asked too many questions. I'm not giving him a permit. Now, in my case, I was asking questions as a member of the media, and I wasn't asking the safe questions that the mainstream media was asking. I was asking things like, when Chelsea King went missing and Gardner was found to be the murderer, they had a DNA sample from Gardner early on that had not been processed in the lab in San Diego. And they had a serious backlog of DNA testing. And if they didn't, they would have known it was Gardner ahead of time. So I sit back and I start asking questions. Well, they don't want to have to answer a question that's going to embarrass their department or any unit in their department. They don't want that. They only want good news, fluff news. And I put it right on Sheriff Bill Gore, saying, look, if you people in San Diego want to be treated appropriately, if you want to have somebody that respects your Second Amendment right to self-defense with a firearm, then you got to get rid of Gore under the current system. And there are candidates that run for sheriff who advocate a more liberal shall issue policy to people who are not disqualified. So, you know, what it's going to come down to is, and I think that Mike Slater was a little taken back because one of the callers that called in told him that if you go to calguns.net, they've actually got a map of the different counties in California, and they're color shaded to who's issuing almost on a shall basis issue and who's restricted. I mean, you know, you got Los Angeles and San Francisco, Los Angeles, and San Diego. You ain't getting a permit. That ain't happening. So
there's a gentleman here in Connecticut, Jonathan Hardy, that also keeps track of issuing authorities here in Connecticut and who issues and who doesn't, because it's all over the board here, as it will be anywhere where you rely on a concept like suitability.
Well, let me just end it with this. I now advocate that President Trump get involved in reciprocity, where a permit from Connecticut will be good in San Diego, California, anywhere in California. But California already has reciprocity within the state. If you get a concealed carry permit in Northern California, you can carry in San Diego under the state reciprocity. So there it is. We're done.
Okay, we're going to get more into reciprocity, actually look at the bill and what's happening in Congress.
And to anybody on Facebook who friended me recently, please keep watching because we're going to be doing a lot of talking about firearms, firearm rights, and San Diego, California.
Okay, and have a great Wednesday. We'll see you back tomorrow morning, 7 a.m. Thanks, Ed.